The Madlanga Commission of Inquiry is facing another legal challenge, and this time, businessman and ANC member Suleiman Karim wants to interdict a subpoena which will compel him to appear before the Commission on Friday. Karim is arguing that the Commission relied on the wrong rules in issuing the subpoena. Our Junior Khumalo will be joining us from Johannesburg, live with more on that perspective, while Ziyanda Ngcobo will be wrapping up some of the highlights from yesterday's testimony. These two proceedings, of course, greatly interconnected. Junior, let's kick off with you. Talk to us a little bit more about who Suleiman Karim is and how he fits into the anatomy of testimony that the Madlanga Commission is wanting to get to the bottom of.
Indeed, Iman, Suleiman Karim is one of those business people from the Northwest that are accused of basically influencing high-level police officials on behalf of individuals such as Vusumuzi Makgotloe. He is not the only one from the Northwest. There is also Brown Mahotsi, who also faces similar allegations against him. And Brown Mahotsi, during his appearance before the commission, also testified about Suleiman Karim and how Suleiman Karim was close to Vusumuzi Makgotloe. So from the evidence that we've had before the commission, two individuals have implicated Suleiman Karim, at least two individuals. Witness X, who was testifying and finishing the testimony that was already started by crime intelligence boss Dumisani Khumalo. This witness X basically said that from the cell phone records that they obtained from Mr. Vusumuzi Makgotloe when he was arrested, they could then identify that Suleiman Karim was a very influential individual when it comes to that 360 million tender that has since been cancelled that Vusumuzi Makgotloe had obtained with the SAPS. From those text messages between the pair, it was very evident that Suleiman Karim had assisted Vusumuzi Makgotloe with some of the invoices that he was busy with when it comes to that particular tender. In return, he is said to have received between 1.5 million rand and 2.5 million rand. In his court papers, he does not contend this, Iman. He does admit that he did receive about 1.5 million, according to him, but he says this was because he had invested about 10 million rand into Mr. Vusumuzi Makgotloe. But coming into why he is taking the commission to this Johannesburg High Court behind me, Mr. Suleiman Karim has been subpoenaed to appear before the commission on Friday. Initially, he was expected to appear before the commission last year in December, but because of scheduling challenges, then this was moved to this year. But even then, Mr. Suleiman Karim had already written to the commission and he was challenging the basis of being called before the commission. The commission had written to him according to Regulation 10.6 of the commission, and he is challenging that particular regulation, saying this regulation allows an individual who is going to be testifying before the commission either to supply an affidavit or to appear in person. But the commission, having asked him to supply an affidavit, also wanted him to appear in person. So his legal representatives were saying that they need to choose one. Either he appears before the commission or they take his responses using that particular affidavit that he's already submitted. But also what they are arguing is that they did not submit a Rule 3 to inform Mr. Suleiman Karim that there are individuals who are going to be testifying and implicating them in their witnesses. So this could have helped his legal team to then be present on the day and also cross-examine these particular witnesses. So that is actually not the only witness that is challenging the proceedings before the commission. Just last week we did hear one of the advocates, Advocate Ngwato, basically challenging the appearance of his client before this particular commission. But today we will be seeing that particular client appearing at the Madlanga Commission, and my colleague Ziyanda is at that particular commission. Ziyanda, what are we expecting from today's proceedings?
Well, a very good morning to you, Junior Khumalo. So much to speak about here at the Bridget Mabandla Justice College. You speak about what we can expect. Well, last Friday, you'll recall that Advocate Ngwato, attorney Advocate Ngwato, was here trying to postpone the testimony of his client, Sergeant Fani Nkosi, which was granted. But the second application was to have his testimony in camera. The commission granting him partial in-camera testimony. In other words, we'll hear their audio, but we will not see them, and they won't be here at this particular venue. Yesterday, we listened into proceedings as Captain Laurance Makgotloe gave a testimony about whether or not he was incompetent, maybe overwhelmed by the backlog at the ballistics lab, or is he being influenced by the criminal cartels that have allegedly infiltrated our criminal justice system. That is the core of what he was testifying about in relation to why there were so many mistakes in his ballistics report in relation to the murder of Armand Swart on the 17th of April 2024. He omitted to actually include the 15 cartridges that were retrieved from the Bramley scene where the suspects linked to Swart's murder in Vereeniging were actually nabbed. Now, another aspect of the testimony given by Makgotloe was that the investigators belonging to the political killings task team, in particular Witness D, had actually kidnapped him and tried to intimidate him. And it's in this report that Junior Khumalo had put together that he reflects on that particular testimony. Let's listen in.
Senior ballistic expert Captain Makgotloe has made startling claims that he was kidnapped and intimidated by officers investigating the murder of Vereeniging engineer Armand Swart. As the ballistic expert in the Swart case, Makgotloe claimed that investigating officers who included members of the KZN political killings task team kidnapped him in January last year. He told the commission that the investigating officers suspected he may have intentionally sabotaged the ballistic test and as such forcefully took him to his office in a bid to confiscate his work computer.
I opened a case of kidnapping on 8 January 2025, which is currently being handled by Independent Police Investigative Director, IP. I stand by the fact that I was kidnapped as I did not give the officers permission to take me anywhere and was forcefully taken by Witness B's team.
Witness B, a crime intelligence officer and lead investigator in the case, told a different story during her testimony in October last year. She claimed that Makgotloe's actions appeared deliberate and were intended to derail investigations.
At the latest, much later stage, I think this year, 5 August, it's only when now the very same Captain Makgotloe gave us a link, a report that is having most of what he alluded then. So somehow, when I look at it, I feel like there is deliberate delays intended in the investigation.
On the same day of Swart's murder, on the 17th of April 2024, Makgotloe had attended the scene in Vereeniging and collected ballistic evidence as exhibits for further examination. On the same day, the accused were arrested in Bramley and linked to the Swart shooting. Guns and ammunition seized at the Bramley case were also later handed to Makgotloe, and therein lay the challenge, according to Witness B's testimony. She claimed that Makgotloe failed to link these guns not only to the Swart killing, but to 30 other cases, despite a second opinion from a KZN ballistics test confirming this. Makgotloe reiterated that the mistakes in the ballistics reports and subsequent amendments that did not follow protocol were not intentional.
As I already indicated, commissioners, that the errors will arise time to time as long as there is still pressure at the lab. The errors will always be there because we push quantities, not quality.
Having heard Makgotloe and the investigating officer's claims, the commission will now have to decide on whether his actions amounted to honest mistakes or attempts to impede an ongoing case. For Newzroom Afrika on Channel 405, I'm Junior Khumalo in Pretoria.
Okay, so quite a comprehensive roundup from Junior Khumalo on yesterday's testimony. As I now bring in Eldred De Klerk, a very good morning to you. Welcome back to Johannesburg.
Thank you, Ziyanda.
It's good to be with you once more. And it's quite interesting how Makgotloe says they push quantity and not quality. Is that something that the commissioners will have to consider? Because how do you prove that the cartels are influencing someone like Makgotloe, as has been alleged?
Absolutely. So you can make these accusations without any proof, and then it's almost incumbent on the person that's been accused to come and prove the innocence. The other startling revelation that he made was that 8 out of 10 reports are sent back after a process of review.
Sure.
That's a lot. That's an 80%
Yeah.
error rate. So if it's true that 8 out of 10 reports are sent back, isn't it plausible then that he could also, under the sheer pressure and weight of having to cover 3 provinces as a forensic officer and having 20 minutes to write a report, rewrite it and correct it and submit it if need be, that errors can occur?
But a very consequential error, because
Absolutely.
once they detected this, 30 cases were linked to this one particular firearm, the murders of DJ somebody, DJ Hector, and Don Tindleni. I mean, this is where I suppose the aspect of the criminal cartels influencing comes in, to the extent that it seems that members of the PKTT deemed it necessary to kidnap him. I'm not sure if that is even an appropriate response.
Absolutely. And yes, it is consequential, the fact that that error led to uncovering and opening up such a big investigation. It's significant. So let's just say that that is so. Whether he did that because he was under any other kind of duress or influence, and they did it on behalf of anybody else, that has yet to be proven. We can just say that it was consequential. Then you said, Ziyanda, which is the other part of the equation, that 2 wrongs don't make a right.
Yeah.
So how then do you go and allegedly kidnap your own colleague because you simply want their computer? Surely there's internal processes that says to me as an investigation that I can fill out a certain paperwork, request a copy to seize your computer, and go and seize it. You don't have to be present when I do so, right? So does that say something about the way that the PKTT works?
Yeah.
Do we then now say that there is suspicion amongst colleagues, and that suspicion bears out the fact that I can't trust how my colleagues works, and does that in any way reflect on the institutional culture where there's deep mistrust between officers and officers of particular units? And we've had little occasions where we were led to believe, sometimes we called it factions.
Yes.
Otherwise, we could have just said they don't trust each other. Whether you don't trust people at a local police station and you don't tell them certain things are going, that's routine. You run an operation, you don't tell the officers in the area. And when we ask why, because they can't be trusted.
Yes.
Now we see that you don't trust people within forensics. You don't trust people within TPCI. So when Malanga continues with its course of correcting and looking for remedies to redress the rot within the institution, we're going to have to address this issue of deep mistrust between colleagues in the same institution.
And as we now look at what else is going to be happening parallel to today's testimony, which we'll get to, is the issue of the court challenge. To my knowledge, this is the first court challenge that this commission is actually facing. And this is on the basis of the subpoena. Mr. Suleiman Karim is saying the wrong, clause has been used to bring him here. But surely that's neither here nor there, and not unless, my knowledge of the Commissions Act is not up to scratch, and I'm not a lawyer, but regardless of such, if you've been mentioned, you should come before the Commission.
Not necessarily, because remember, just because they mention my name and say that I'm up to something or I've been part of something, yes, I can pursue every avenue not to get to a point where I either incriminate myself or I haven't actually heard and seen the testimony or the evidence against me. I am entitled to due process. because they go further to say that he was never told that he was going to be mentioned.
Yes.
He was not, the evidence against him or the affidavits were never presented to him. And now he needs to prepare a case where he's actually coming to defend himself. And he has to address things that he may not have known before. Everybody's entitled to due process. And if there's an opportunity to go to a court of law to travel a process, you're entitled to it. All of us should accept that and understand that, therefore, the courts are independent, and they will now, at the sober as a judge, they say,
yeah,
will make a determination as to whether he, in fact, has to come. And once he's exhausted his remedies, because we have the same question with the subpoenas that the ad hoc committee is trying to get, that there's not been an exhaustion of remedies. So here, an individual will exhaust all remedies in front of him or her. Once that's done, the subpoena stands if they find against him. But then at least we've had a clear, fair, and just process that if the subpoena then stands,
yeah,
and we've addressed every issue, then you can't say that you've been done an injustice.
It's going to be so interesting to listen to those arguments that have been brought on an urgent basis. Eldred De Klerk, thank you very much, as we're going to be monitoring these two processes that